Senator Fawcett.
Thank you, Mr Acting Deputy President. I'd like to rise to make some comments on this bill, which is in response to the postal survey, which, as everyone knows by now, delivered on the 15th of November, indicated the will of the Australian people, some 61%, to change the definition of marriage. I do so in the context as the chair of the then Senate Select Committee, which was appointed late last year following a motion in this chamber to examine the implications for religious freedom should a bill to change the definition of marriage be passed in the Australian Parliament. And that's probably the most extensive examination of this specific issue that I think Australia has had, certainly for some years, if not ever, looking particularly at issues of freedom of religious and conscientious belief in the context of a change to the laws around marriage. And where we're at today, I think there is an acceptance, certainly by the vast majority of people in this place, that the Australian people have spoken, and so without unnecessary delay we need to pass the legislation through both the Senate and the House to respect the will of the Australian people. But there is also a need to do it in a balanced way that respects the rights and the beliefs of nearly 40% of the Australian people. And that's what the Senate Select Committee sought to examine and understand, was how would you go about that? Now, one of the disappointments I have coming out of the Senate Select Committee is that many people seized on the word consensus and said, we have a consensus report, therefore it gives us a roadmap on the way ahead. But it's a little deeper than that. I'd just like to cover off on some of the issues where we did find consensus, because they go to the debate that we'll be having in this chamber over the coming days about how we find that balance between the differing views of people in the Australian population, as well as what I think were some of the important things that we recognised about our society during that debate, which, moving forward, I think we also need to address. I'll then talk a little bit about some of the ways to remedy the lack of balance that could potentially exist following a change, some specific amendments that I foreshadow now that I'll be moving in conjunction with my colleague Senator Patterson in this place during the committee stage. So the first consensus that the committee reached, which surprised a lot of people, was there was a consensus between the members of the committee, which were drawn from across the parliament, Xenophon team, Greens, Labor and the Nationals and Liberal, was that despite the rhetoric that said this was an issue of human rights, that there was discrimination, the committee found, with a consensus view, that under international law, both the United Nations Human Rights Committee findings and also the European Court of Human Rights, that Australia in fact did not breach any of its obligations under international human rights law with respect to either equality or discrimination by holding that marriage was between a man and a woman. And as long as we recognised and protected same-sex relationships through another structure, that held to be true. Now that's an important starting point, because if there is no discrimination under international law, then there is no basis upon which you can derogate another right. And so as we come to this discussion around people's conscientious and religious beliefs, if there is no discrimination to start with, then there is no basis upon which you can derogate or remove somebody's rights. So that's an important starting point that I think we need to keep in mind. The other conclusion that we came to unanimously, which again has not been discussed by many people in this debate, is that it is complex. There are a complex range of issues which go to the intersection of state and federal laws, but even federally into things like charity and tax law, which are all tied up with the definition of marriage. Now that surprised a lot of people, and the committee recognised that there was a deficit in the protection of religious freedoms across the nation. That was a consensus view. They recognised the complexity, and they recognised that, and I'll quote from the executive summary, that should legislation be enacted to change the definition of marriage, careful attention is required to understand and deliver a balanced outcome that respects the human rights of all Australians if the nation is to continue to be a tolerant and plural society where a diversity of views is not only legal but valued. And so I guess my disappointment, having now had the survey, and because people have not been prepared to engage with that sentiment from the Senate Select Committee report and examine these things in detail between then and now, we're left in this week of debate here in the Senate to canvass some issues that are relatively complex but need to be considered by the Senate if we're going to get a balanced outcome. One of the other things that was done after that inquiry was kicking off the Joint Standing Committee Foreign Affairs, Defence and Trade inquiry into the status of freedom of religion and belief here in Australia, so that we actually have a good benchmark that now the work Mr Ruddock will be doing can actually look at how we might implement that in the future. But that's a very broad issue, and if I look back to the recommendations or the comments from the Senate Select Committee, we recognise that addressing that deficit in freedom of religion could go at one end of the spectrum, from a Bill of Human Rights, which I personally don't support, through to the concept of anti-detriment provisions, which was one of the likely models that the committee said would probably work, or trying to align anti-discrimination laws across our various states and territories. And I would just note for the chamber that the last time that was attempted was when Nicola Roxon was the Attorney-General, and the process proved to be so complex that essentially it was shelved because it was too hard to get that many different legislatures to agree on what the standards can be and how they should align. So I have little confidence that that approach of trying to align laws across the whole range of issues that would be engaged in this would work. So that brings us to the survey. And I know there's been disagreement on the concept, but personally I'm happy that the Australian people have had their say. The outcome was not what I voted for, but I respect the fact that we have a clear outcome. The conduct was positive, some 80% or just under. Given it was a voluntary survey, I think was very successful. The context, though, of how the survey and how the community responded, I think is important as we come to this debate, because people have been told by political leaders and other advocates that there is nothing to be concerned about in terms of their religious freedoms and their ability to associate or speak freely, some of the basic freedoms that we enjoy in this plural society that we live in. But when you look back over the period of the survey, and indeed the months leading up to it, whilst there was a lot of concern about what the No campaign may do, what we saw, and while there were some fringe elements on both sides, I think it would be fair to say that you could characterise some of the worst breaches of what we would call civilised conduct in the country were some of the blockade-type protests by Yes campaigners that sought to frustrate the ability of people to meet and associate and discuss these issues. We saw, for example, media fraud, where the media who saw a Twitter or a Facebook post about a poster that was supposed to be in Melbourne actually fabricated an image to put on the nightly news, and so again swayed opinion, even though there was no basis of fact to what they had put up, as well as boycotts, whether it be pubs who said we will no longer allow Christian groups to come and hold events here, printers who said we won't print the book because we don't agree with your point of view, or advertising agencies who actually used denial of service as a virtue signalling exercise. I think what we saw there is that people who hold to a traditional view of marriage have seen a number of their rights to speak, to associate, taken away by a fairly strong advocacy by businesses, by activists and by others. And so they're concerned, as they look at the overseas experience plus the experience here, about what the impact might be. Now, these are not people who are undesirables. And in fact, I go back to the US Supreme Court when they had the decision in 2015 to legalise same-sex marriage, and they expressed the view that, and I'm quoting, "Marriage is by its nature a gender-differentiated union of a man and woman, has long been held and continues to be held in good faith by reasonable and sincere people here and throughout the world." And I think that is true of the nearly 40% of Australians who voted no in this survey. So the interesting part is that whilst there were 61.4% of people who voted yes, there were 62% of people, according to Newspoll, who said, regardless of whether they vote yes or no, that protections are important. And that's why we need to understand why we need to address it in this bill. So we've heard a number of comments of people saying there is nothing in this bill that enlivens discrimination or takes away protections for people, and nothing in federal law. And to a large extent that is true. But what we've seen, both in evidence to the Senate Select Committee and since, is that it's the operation of state and territory anti-discrimination and anti-vilification laws which are actually the things that chill the ability of people to have free speech, in some cases freedom of association, that have caused concerns. And so the amendments that we're looking for here are amendments not to create any new forms of discrimination, but in fact to prevent discrimination against what is, if you like, the new minority in Australia, and that is people who hold that marriage should be between a man and a woman. And the issue with the state and territory laws is they vary across the states. So South Australia and New South Wales, for example, have no protection in law for religious freedoms. The ACT probably has the most robust, Victoria has some, but across the states and territories there is a vastly different standard applied in each state. And it's to the extent where the Human Rights Commission here has called on a couple of occasions for the Australian government to look at legislating for Article 18, and in fact the United Nations Sixth Periodic Review of Australia and its human rights have called for us to implement Article 18. Why is that important? Because under law, if you're trying to balance two competing rights, but only one of them is in your domestic law, then it's very hard to find the balance because there is no counterweight, there's no counterbalance that the judiciary can apply there, using things like the Syracuse principles that the United Nations have come up with as the way to find that balance when inevitably the human rights that each of us enjoy, and it is each individual person, come into conflict. The UN, in their various guidance notes or comments around the human rights outlined in the ICCPR, are very clear that there is no one right that trumps another. You do need to find a balance, but the starting point for that is having, in an operational sense, those elements in our legislation here, and preferably in a consistent national standard. So the amendments that I'm foreshadowing are limited in scope. As I look back at Nicola Roxon's difficulties in trying to align anti-discrimination law, I recognise that the only way we will do this in a timely manner, if at all, is to limit the scope so that it deals with the topics that we dealt with during the Senate Select Committee, and that's around the issue of marriage and how we balance those two competing rights. They are based predominantly on the concept of anti-detriment provisions, and importantly they act as a shield. So it's not licensing people to discriminate, but it's saying if you express your view and you are discriminated against, here is a protection for you. So to give you some examples, the anti-detriment by public authorities. What we saw in Tasmania with Archbishop Porteous was that when he wrote a pastoral letter to the parents of children at a Catholic school, he was taken to the Anti-Discrimination Tribunal because somebody took offence and felt vilified by what he had said. Now, having read the content of what he said, it is not controversial at all. It was very mild in its tone, it was very compassionate and embracing in the way he wrote, but he wrote the view that the Catholic Church has about marriage and family. Now, many people think that that case was dismissed by the tribunal in Tasmania, but in actual fact, in evidence to the committee, the Commissioner indicated that no, the complaint had been withdrawn, which means there is no case law which means that that action could be taken again. And Archbishop Portis highlighted the tens of thousands of dollars, the months of angst that he and the Catholic Church went through getting ready to defend that case, and that possibility remains open now. In fact, there are two other individuals in Tasmania, one a pastor, one associated with a church, who are currently before the commission down there again because they were speaking out the church's view on what marriage was, and they have been taken to account over that. We see similar things overseas, detriment being applied by government-like agencies, so organisations who register teachers or lawyers, for example, refusing to allow into the teaching profession or the legal profession, this is in Canada, graduates of a university that holds to the traditional view of marriage. We see in the UK students kicked off their courses because they express a view supporting the traditional view of marriage, and even through to the High Court, that removal from the course has been held to be appropriate because at some point in the future they might offend someone. And so we see someone's ability to actually complete education, move into a career, limited by the state because they hold a traditional view around marriage. We heard a lot of evidence during the Senate committee around the impact on charities and the two laws in terms of the public benefit and public policy tests that we share in common with other nations such as the UK and New Zealand, and we have seen charities disadvantaged there as a consequence to the change in the marriage laws. We've seen similar decisions taken here already, where, for example, St Vincent de Paul's has been held to not be a religious body, and that has flow-on effects for things like the Sex Discrimination Act and exemptions around their views on marriage under that. Parents. For many years, Australia has had a pretty common-sense approach to the parents' rights to oversee the moral education of their children in accordance with their convictions. If you have your child in a primary school, then a parent can say, look, I don't want them to take part in the RE class, thanks very much. They can go to the library, they can do an alternate class, they can play some sport. Everybody's been relaxed about that sensible accommodation. But what we're increasingly seeing is that when it comes to other issues that have the title of equality around it, that same right, which is guaranteed under Article 18.4 of the ICCPR, is not being afforded to parents. And it's got to the extent in South Australia where, following a change to the Sex Discrimination Act, a federal piece of legislation to include gender issues, the South Australia has now issued directives to principals in its school to implement programs around gender fluidity, and that the principal is to override the will of the parents if their son or daughter wishes to transition their gender, even in primary schools. Now, I think most Australians would think that that is just beyond the pale, but that's what we see currently. And so, again, a change in federal legislation around marriage in the current climate can be expected to lead to the same situation as we've seen overseas, where parents are unable to have the say in the education or the things that their children are exposed to. Freedom of expression. People need to be free to express, not in a way that threatens or harasses, and because we have such a lack of standardisation around the country, these amendments look at using the Sex Discrimination Act with some amendments to provide a standard basis across the country. There's also things around protection of religious bodies and schools, celebrants. I'm aware that both the Attorney-General and I think Senator Leyonhjelm had some amendments on that, and that came up during the Senate committee report, and we will certainly be looking to support that. Why are these protections important? The evidence we saw in the Senate committee said that the current protections are inadequate. We've seen from overseas, we've seen already in Australia that actions are being taken, and the reality is that the change of the definition of marriage is not the end of the story. We've seen in the UK, we've seen in the US, we've seen in Canada, people saying there is more to do. The Speaker of the House of Commons in the UK has said we won't have true marriage equality until we've got rid of all these protections for churches and other things, and anyone can get married in any church. If we're going to make this change to a fundamental institution in our society, then we need at the same time to put in place the protections so that we protect the rights of all Australians in a balanced and reasonable way, and not just kick the can down the road for some future inquiry that may or may not result in the balance that Australia needs to be a plural and inclusive society.
Senator Fawcett.